So if your client refuses to pay your bill, keeps quibbling over it, suggests that they're going to reduce the future bills, well, can you just say, hang on, this is not what we agreed to. Why don't we just temporarily stop work until we can negotiate and agree the way forward? Or is that a really, really risky strategy? Well, English case law, it's not exactly precise on this. Generally speaking, if you suspend works without a lawful excuse, then that can be the same as abandoning the project. And abandoning the project means the other side can treat the contract as terminated and claim compensation from you. That's obviously going to be a bad place to be in. But what if, for example, they're refusing to pay your bills, trying to renegotiate the deal, and you say, well, pending resolution of these issues, we don't intend to carry out any more work, but we will once we've come to an agreement. That might give everyone the time and the space to actually sit down and do that agreement. Now, there have been cases on this, and there was a case in 2020 where on a residential project not very far from me in Worsley, Manchester, the clients had not paid the third valuation of the contractor. There was about £40,000 that it had claimed. Now, there was some debate about some of the items on that bill, but the client basically sat down and said, not sure about this, not sure whether we need to reduce the future scope, reduce the prices that we've got in the contract for the remaining scope, and we're not going to pay you in the meantime. Following that meeting, the contractor sent an email which clearly stated that there was a bit of a problem. They needed to decide what the future scope of the work was, what the valuation for the work that they'd already carried out was, and therefore kind of to settle the position. And they basically said, until these things are resolved, we don't intend to carry out any more work. Quite reasonably, they were trying to protect their interests. But it was a risky strategy because it ended up going to court, which means one firm of lawyers told the clients, the people who own the property, well, that's a breach of contract. The court had to look at it based on the facts. The question is, are they refusing to carry out the work, or are they saying we're going to stop until we resolve these existing issues? And there were genuine existing issues between the parties. So it wasn't without lawful excuse. It wasn't that they had better things to do, sunning themselves on the beach, another more profitable project or whatever. But there were also legitimate concerns that the contractor had that the clients basically didn't have the money to pay for both the works they'd already carried out and the works that they were due to do in the future. A tricky position for both of them to be in. And it turned out the courts actually agreed that the contractor had a right to suspend works temporarily whilst these issues were resolved. But the clients in the meantime had decided that that was akin to abandoning the project. They asked them to remove the scaffolding, got somebody else in. That was kind of like the make or break. Once you've got somebody else in to carry out the project, well, you've got to have ended the first contract. And that's what had happened. So the compensation swingometer goes between the client and the contractor, depending on who's right in that situation. These are really tricky decisions to make. They're often done in an emotional state. They're often done in the heat of the moment. They're often done when you've got the pressures of, do we continue on this project and hope we'll get paid, or we've got to pay our subcontractors? How is that going to work out for us? There's an awful lot of pressure on both parties at this point. But if you do find yourself in this situation, please, 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 please get legal advice. I'm not one for asking you to run to your lawyers at every opportunity, but this is a time when you can get it catastrophically wrong. And instead of being entitled to compensation, end up having to pay compensation. That can be the most expensive mistake you make on a project. So if you can resolve it, resolve it. Sit down. If you can't because tempers are frayed, people have got a bit cross with each other, maybe ask someone independent to come and help you resolve this matter between you, and quickly. An independent surveyor, an expert witness, a solicitor friend, that kind of thing. But don't kind of wing it. This is not a place where winging it will ever do you any favours. These sort of cases are expensive, time consuming, energy draining, and don't actually get your project built or your bills paid. So think carefully before you decide whether or not you've got a right to suspend. If you think this is something you need in your projects, in your contracts, write it in. Put a clear right to suspend in, not just for non-payment, which wouldn't apply under English law on this project because it was somebody's home, a residential project, so statutory right to suspend didn't apply. But if you think it's the sort of thing you might want, there's a pandemic, a war, horrible virus, a zombie apocalypse, whatever, make sure you've got a right in your contract to do so, because there is no real common law, case law right to suspend under English law. So be careful, because this point where you might want to suspend, you may not be on the best of terms, and so negotiating your way out of that deal could be difficult. So have a think. Do your contracts and all the rights and remedies in them safeguard your business without annoying your clients, or do they leave you in contractual limbo? Let's go for clarity where possible.